Welcome back to my YouTube channel, VaJee Law, a Center for Legal Excellence. In the series of IBC Amendment Act 2026, we are again back with an amendment introduced in Section 43, subsection 4 of the Principal Act. Let's go through it in detail. What is exactly represents a strategic evolution in the law ability to claw back assets that were unfairly transferred prior to insolvency. By the shift of this focus from the date of admission to the date of filing, the legislature has effectively neutralizes a common tactic used to shield suspect transaction and from the judicial scrutiny. Let's go through into detail. First, first one is tactical linguistic shift. The amendment replaces static words with a language that defines a continuous, expanded span of time. Uh, Period starting from replaces period of. This indicates that relevant time is no longer a fixed block of 1 year or 2 year, but a continuous duration that begins at the specific historical point. And next is initiation date and ending date on insolvency commencement date replaces insolvency commencement date. This defines the end point of the window, ensuring it covers everything up to the moment the insolvency process officially starts. Anchoring point is filing versus admission. The most profound, the I hope is clearly visible. The most profound change in reference point for calculating the look-back period. Previously, previous reference is to admission. Under the original section 43, the look-back period is 1 year for others and 2 years for the related party. Was counted backward from the insolvency commencement date (ICD) date. Okay, which is the date that NCLT particularly admit that application. And you all are aware that there is a huge delay in admission as blamed of, but there is a delay on the part of every stakeholder. And next is the 2026 amendment anchors the look back period to the initiation date, which is the date of application for insolvency was first filed with the adjudicating authority. Now, next is neutralizing the admission bottleneck. The primary strategic goal is the primary strategic goal of this amendment is to address what identified as the twilight period or the admission bottleneck period. Historically, there have been significant delay between the filing of the insolvency application and its admission, at times extending up to 1 year or 2 years due to infrastructure issues and litigations and settlement. Council are not prepared. They didn't file a reply on time. There are a number of problems. And during this long delay, the corporate debtor remains in control of its asset. And shrewd management, shrewd promoter, what they do, they uses this twilight zone to give a preference to favorite creditors, knowing that if their delay was long enough, those transactions would fall outside the purview look back period, that is 1 year for other and 2 year for related party, and by the time the case was finally admitted, they just delay the matter so that that transaction is out of that look back period. Okay, the solution is how the new amendment closes this gap by stating the clock at the initiation date of filing, and extending it through the ICD, matlab insolvency commencement date, and the law now captures every transaction made during the entire pendency of admission proceedings, in addition to the standard pre-filing look-back period. Okay. Next is preventing date shopping. This amendment particularly prevent date shopping as well. 2026 Act ensures that party cannot manipulate the relevant time by filing a multiple application. The first filing rule, Section 5, subsection 11, clarify added. There is a new proviso in Section 5, subsection 11 clarifies that if a multiple application are pending against the same debtor, the initiation date is the date of first such application was made. Uh, this prevents the debtor from attempting to reset the clock look back period by filing the newer application or pushing for its admission over an older one, thereby potentially moving suspect transaction out of the relevant time. This is removed. Now, next is strategic impact. What is the strategic summary of the window expansion? If To illustrate, if a case is filed, say suppose January 2024 and admitted in 1st January 2025, the relevant time for a non-related party would be before the amendment, if we see that 1 year, which is if it is admitted in 2025, that is 1 year 2024, 1 year. And for a but after admission January 1, 2023, 1 year before filing to January 1, 2025 to admission. Resulting, this amendment effectively doubles the protected window in this scenario, ensuring that transactions made before filing and during the judicial delay are eligible for avoidance applications. What is the strategic of this whole amendment? That changes make the recovery framework significantly more robust and ensuring that value erosion during judicial delay is minimized and the objective of value maximization for the creditor estate is upheld. This is the whole objective, to revive a CD and protect the interest of every stakeholder. Thank you.